allegation as opposed to the criminal charge that would have been sworn.
Okay, so in other words, the whomever signed something, I guess is what you're indicating, they signed for something that was changed?
Correct.
Okay, was there any updated acknowledgement of this change to expect an appearance?
There doesn't need to be and this is starting to get into legal advice, so I don't know how far I can go with you into this because it's starting to get above my pay grade. I'm not a lawyer. I don't know.
I wouldn't hold you to it. I'm not holding you to it. Not holding you to it. I'm just trying to get more than what the website says.
Yeah, so basically and again, I don't know exactly how it works, so please don't take me for word, but my understanding is that when the police submit all of their documents, the Crown has the authority to change the charges that come before them. They can either add them or just get rid of them altogether. In this particular case, the allegation is actually like a lesser charge. So the uttering threats is an actual criminal offense that if someone was found guilty, it would show up on their criminal record check, whereas the allegation wouldn't be. So the Crown did bring it down to the 810 peace bond, and then when they submitted that information for the justice to swear, they would explain why they went from uttering threats down to the 810 allegation.
Okay. So you're saying that they arrested someone under the threat of arrest for uttering threats, but then that was never laid, or was that laid and then altered?
So it wasn't technically laid. It was presented to the Crown Counsel as the RCMP said we arrested them based on the information we have. And I'm assuming they were arrested. Sometimes they're not arrested. The police just, I don't know exactly what happened in the background with the RCMP. But if the person was arrested for, they say, the RCMP say, we found this guy, he was, screaming bloody murder, whatever, I don't know, at somebody. So we think that you should charge them with uttering threats. Here's our information. Crown, we think you should charge them with uttering threats. Crown then looks at it, goes, yeah, no, it's not, we're not going to meet the threshold that Crown has to meet, which is the innocent until proven guilty. And we aren't able, we don't think that that this would move forward in court, but we do think that this person has some fear potentially of this defendant. So we are going to move forward with the peace bond.
Okay, for sure.